argument. That is case number 118239, Northern Natural Gas Company v. One Oak Field Services Company et al., appellees.
Good morning. May it please the court, Richard Olmstead appearing today on behalf of Northern Natural Gas Company. I'm joined today by Northern's Associate General Counsel, or Assistant General Counsel, Jim Talcott, and with me at council table is Corey Neller, who was with me on the briefs. I would like to reserve, please, 5 minutes for rebuttal.
5 minutes is granted.
Before I begin, I'd also like to apologize for appearing before the court today wearing khakis. My suit pants, I believe, are laying in the parking lot at the Hertz rental car in Wichita, Kansas. So normally I would not appear in a full suit, but those are the circumstances today. This case is before the court for the second time. The case involves who owns storage gas that has been produced. Northern Natural Gas Company operates the Cunningham storage field in Pratt, Kingman, and Reno County, Kansas. It injects gas underground for storage purposes. The parties in this case have been involved in litigation for many years, revolving around a group of oil and gas producers, which are referred to as the producers in this case, who have produced storage gas that has been pulled from the Cunningham storage field to their wells that sit roughly anywhere between 4 to 6 miles away from what were the original certificated boundaries of the Cunningham storage field. When we were last before the court, the issue was who owns the storage gas that they produced based on the then certificated boundaries of the storage field. And the court, relying on KSA 55-1210C, said because these wells were located on property that does not adjoin the storage field, that what the storage gas that they produced, is subject to the rule of capture in a series of cases announced by the court, Anderson versus Beach Aircraft and Union Gas Systems, Inc. versus Carnahan. Today, we're here because circumstances have changed. On June 2nd, 2010, the Federal Energy Regulatory Commission granted Northern Natural Gas Company a certificate of public convenience of necessity, allowing Northern to expand the certificated boundaries of the storage field.
And yes. The telling word there is allowed. That certificate of convenience and necessity simply is a condition precedent to an eminent domain.
The certificate gives Northern the authority pursuant to the Natural Gas Act to exercise its eminent domain powers, yes. But on the date of certificate, the federal legal certificated boundaries of the Cunningham storage field include that new acreage that includes the producer's wells.
But vis-a-vis the landowners that are within that boundary, why does the certificate transfer a right in the real estate?
Well, it doesn't transfer a right to the real estate, Your Honor. That's the difference between the date of certificate and the date of taking. Northern acquires no rights in the real estate until the date of taking and condemnation. But on the date of certificate, this court's authority says that on the date of certificate, the right to produce storage gas that is migrated from a underground storage field expires by operation of Kansas law. And on that certificate date...
You're basing that on Union Gas.
On Union Gas, yes, Your Honor. And as well as on One Oak, where the court held on page 936 of that opinion, the producers had title to any migrating storage gas produced by their wells until June 2nd, 2010, when FERC extended the certificated boundaries of the field to include the area of their wells. There has been no change in the law since 1988, excuse me, when the Union Gas case was decided. The facts of this case are indistinguishable from Union Gas.
Let me ask you about that statement.
Yes, sir.
Because, and of course it's been repeated about a dozen times, the quote from Martin Pringle case about that the landowners possess the legal right to produce the migrated gas until you get the certificate, and then then the phrase I want to ask you about, which I know you know, is "and paid them for that privilege through a condemnation action." How do we reconcile that statement from Martin Pringle with Union Gas? Because it seems to me to be directly contradicting each other.
There are a couple important points to be made. First, that passage is preceded by the introductory language that says prior to July 1st, 1993. So in that paragraph, the court in Martin Pringle was telling the world what the law was prior to July 1st, 1993. Well, the only case out there that discusses what the law is prior to July 1st, 1993 is Union Gas. So it's our position that the court was summarizing Union Gas with that statement. And when it says...
But Union Gas said you didn't have to have the condemnation.
Well,
it said you said get the certificate.
I agree, and I'll continue. Okay. So when the court says it has to condemn the property and pay for that privilege, two things. Martin Pringle did not address the timing of payment, and it did not address the importance of certification. Union Gas says on the date of certificate, the storage operator owns the gas. The privilege that must be paid for in a condemnation of this nature is the privilege of the storage operator storing its gas under the newly certificated property from the date of certificate to the date of taking. That's payment through a reasonable rental rate. That was Union Gas. Union Gas directly addressed the question of whether the operator has to pay for the storage gas, and the court said no. We have a statute on the books. KSA 55-1205 directly says, in this situation, the only thing that the storage operator pays for is native gas underlying the property. That, excuse me, that statute, 55-1205, has been on the books since the 1950s. When 55-1210 was adopted in 1993, if, as the position taken by the district court and the position taken by the producers in this case is correct, and that they actually owned the storage gas under the ground, that cannot be reconciled with 55-1205. Because 55-1205 says in condemnation of an underground gas storage field, the only thing you pay for is for the native gas.
And I think part of that gets me to my next question, which was going to be my first question. This is a conversion action, and typically in a conversion action, the converter has to pay the value of the property converted, plus interest. Union Gas tells us that's not the value of this migrated gas. Union Gas tells us that it's the net. You have to deduct the value of this gas, which is what Union Gas said the condemnation offset was the value minus the production cost. And so how do you reconcile your claim for conversion, which has a meaning and a value that's used there, with Union Gas, which you embrace otherwise, which values your gas differently?
Yeah. Well, unfortunately, Your Honor, we've never even gotten to the point of discovery in this case, so we haven't even got to the point of addressing damages. I believe that issue would come up if we ever needed to address damages. In addition, we have the separate condemnation action in federal court. And in federal court, one of the issues that's being decided is whether or not Northern is entitled to a set-off. And in that set-off, Northern would obviously have to account for the production cost. But in this, a conversion claim, which is a tort, an intentional tort under Kansas law, it's damages that are awarded, and the measure of damages is the market value of whatever has been converted.
But it gets back to the right to produce. And Union Gas seems to tell me that the producers and the landowners had a right to produce. They just had to account for the value through the offset when you got to the condemnation. It didn't take away their ability to produce.
Now, I think you're reading Union Gas incorrectly, Your Honor, because the argument that was made in Union Gas, the Carnahan said, hey, we should be paid for the value of storage gas underlying our property. And the court says, no, absolutely not. 55-1205 says you don't get paid for that. The other issue was who retains the value for the storage gas that was produced after the date of certificate until the date of taking, which is the exact issue that we're dealing with in this case. And the court said that gas was Union's. Once the certificate issued, the storage operator owned that gas. So Union, in that case,
that's not the question.
The
question, as I understood my colleague to ask, is if even if you agree that certification gives title back or arises the title in your client, the question was, does that also preclude? Do they have to shut down the well on the date of certificate extension.
Well, in terms of the shutting down, there's nothing in Union Gas that says you have to shut it down. In the federal court, we actually secured an order requiring them to shut it down. And I think I understand the distinction. In the condemnation case, which this is not, in the condemnation case, with regard to the storage gas that was produced after the date of certificate until the date of taking, the landowners, the producers, all interest owners are going to be compensated in terms of calculating the set-off. At least this is what we've argued. In calculating the set-off, they're going to be compensated for their
I
production
understand
costs.
that, but it seems to me that it is an important question because we're talking about right of control. We're talking, because we already have, you're saying that your client always owned that injected gas, just subject to the rule of capture, and when the certificate was issued, then the rule of capture was extinguished, so their control over it reverted to what an owner had. But when we're talking about Union Gas's fiction of it belongs to the injector, then it's under the control of the landowner who has control over it and can capture it, can do what it wants, and then it reverts back to the injector. I think the level of control that one has over property dictates what kind of ownership incidents you have, doesn't it?
Well, I perhaps, but I think the legislature has actually addressed this. The legislature has said in 551210B, no one shall interfere with storage gas within the boundaries of a storage field. We have on June 2nd,
Well,
2010.
you lost that in the last case.
Except we're in different circumstances now. We have certificated boundaries. The federal government has said this as of June 2nd, 2010, the Cunningham storage field, as recognized in the eyes of federal law, is the area that encompasses the producer's wells. 551210B says you cannot interfere with storage gas within the boundaries of a storage field.
I guess that's a matter of semantics. You say the Cunningham field was extended as of 6/2/2010, but that's not really true. You had a certificate of necessity that allowed you to extend it, but you have to take one more step. That certificate only allows you to fulfill the condition preceding to bring an eminent domain as a private company taking a private land, but you had to perform that next step in order to accomplish the extension. And I don't understand how the certificate rises to a level of affecting anyone's rights until you take the step that the certificate allows you to take.
Yeah, I do realize that I'm cutting into my rebuttal time. I'd like to answer your question and then reserve the rest of my time for rebuttal. And the answer is this, that's the distinction that the Supreme Court recognized in Union Gas. The Supreme Court recognized in Union Gas on the date of certificate, storage operations in the newly certificated area are given the official sanction of law. They're given a distinction in Kansas law where they become the storage gas becomes an exception to the rule of capture as announced in Anderson. Now, Northern will not acquire, and has not acquired, well actually it has, will not acquire the actual property rights, the real property interest in the extension area until payment on the date of taking, and that was March 30th, 2012 in this case. But those are the facts of Union Gas. They were given official sanction of law on the date of certificate. In the date of taking, which was a year and a half later in Union Gas, when payment was made, that's when the actual property rights were acquired.
Let me, is it possible to abandon a certificate of convenience without taking the condemnation step? In other words, you get permission, but then you decide you don't want to do it. And is that possible under the federal regs or the federal law?
No, Northern would have to go to the Federal Energy Regulatory Commission and receive permission to abandon that interest. Okay. Northern has an obligation with the issuance of that certificate, whether by contract or condemnation, to go and acquire all of the land that was certificated for storage.
And what happens if you abandon the certificate to the landowners and the producers' ability to?
I assume,
operate?
I assume, Your Honor, I don't know because we've never abandoned, but I assume that if they go through the step of receiving federal approval to abandon jurisdictional facilities, at that point, all of the rights, interests that existed prior to certification revert back to the landowner. So to the extent that the storage field operator had acquired by fee simple interest in payment through condemnation, the property interest in the underground storage formation, if it's abandoned, then presumably the fee owner of the rest of the parcel would, ownership would revert to them. But I don't, as we sit here today, I don't know the answer.
I know, it just seems like an odd thing to be talking about these rights bouncing, you know, sort of in and out of the pockets of the producers and the landowners just based on whether the certificate is in existence or it's been abandoned.
Well, and I think what we have to remember here, and Professor Pierce has noted this in several law review articles where he's done a survey of law, is what we have here is a balancing of rights. And it started in the Anderson case. And it's a balancing of a producer's right to produce the wells on their property with an injector's rights to protect its own storage gas. And the one message that has been clear in Anderson, Union Gas, in Martin Pringle, and in ONEOK is that if a storage operator wants to protect its rights, and I know this because I've been on the losing end of most of these cases, but if a storage operator wants to protect its rights, it needs to get certification. And when it does all that it's permitted to do under the law to get that certificate, its rights are protected. And that's where the balancing is drawn, because Kansas has never recognized, while it's recognized a right to capture migrated storage gas, it has never recognized a right to capture storage gas from within the certificated boundaries of a storage field. And I think that is the important distinction in this case.
And
Is-
you, excuse me,
Go
let me
ahead.
follow up real quick. And you make the argument that it doesn't matter in this case that the certificate does not allow your client to store any gas in the extended area. Is that correct?
Well, that's an incorrect statement.
Okay.
The certificate does not allow Northern to inject gas into the storage area. We're storing gas in that area right now.
Okay.
That was the original, and unbeknownst to Northern, when the Cunningham storage field was originally developed, gas was stored in that area. It was through later discoveries as data became available to them that they realized that. But gas is stored there, and there's nothing in the certificate that prevents gas from being stored there.
Is it an oversimplification to say that choosing the date of either the certificate being issued or the condemnation being effective really only changes the measure of damages or the formula for calculating the damages to the landowner? That the landowner will receive compensation for the loss of use of their own native gas in either situation. So what they're losing is the production of damage, or what they might have produced in that gap, but they would have to pay that arguably back.
Right. What they're losing is the value of the storage gas that was
gas.
produced after the data certificate. And again, that's the balancing that Professor Pierce talks about. Because in exchange for the loss of the right to produce storage gas, the landowners and the interest owners are compensated for native gas. They're entitled, as the 101 opinion recognized, they're entitled to keep the proceeds of all storage gas that they were able to produce prior to the certification. And they're also going to receive compensation for the use of their underground reservoir for storage until the date of taking.
Do we have any further questions? Thank you, counsel.
Thank you.
May it please the court, my name is Jim Armstrong. I represent one of the producers, LD Drilling, but I'm making the argument on behalf of all the producers and the purchasers, in other words, all appellees in the case. This court should affirm the district court's ruling and hold that the producers and the landowners' clearly established ownership interest did not simply wipe out upon the issuance of the FERC certificate. Northern's argument in that regard is contrary to Kansas law and would amount to an unconstitutional taking of private property without just compensation in violation of the Fifth Amendment. Northern relies on two fundamentally flawed propositions in support of its argument. The first is that on June 1, 2010, the day before the FERC certificate issued, the landowners and the producers actually only had a right to capture gas. They didn't have a vested ownership interest in it. That's the distinction they make. And therefore they argue that if you hadn't captured the gas by production by the time the FERC certificate was issued, then you lose all of your rights to do so after that. That simply does not square with Kansas law. Kansas law, particularly as it has developed after Union Gas, and Union Gas, of course, is the principal case. It's the only case they really rely on. But after Union Gas, in both Martin Pringle and the One Oak decision, this court clearly said that there is a present estate in the oil and gas in the ground at any particular point in time. Now that clearly includes ownership interest and the right to produce.
But Martin Pringle was a question reserved that dealt with pre-statute. What was the effect prior to the whatever it is,
55, 12, 10.
1210.
Right.
And so that didn't deal with our situation because it was under the narrow question.
Well, it's very analogous to the argument that Northern is making here, in that Northern argued in the Martin Pringle case that gas that had migrated under adjoining property before the statute was passed in 1993, but that had not been produced at that time, even though Northern had lost title to that gas before the statute, it instantly revested in Northern with the passage of 55-1210. This court rejected that.
That was just on the basis of whether 1210 applied prospectively or retroactively.
That was the ultimate decision. That's right.
And the statute manifested a legislative intent to treat injected gas differently than native gas, didn't it?
Only in one respect, and that is to adjoining property. What this court clearly held in
Well, that's clearly different than common law with respect to native gas.
That's correct. But if the gas had migrated beyond adjoining property, and this court in One Oak 1 said this very clearly, 55-1210C preserves the rule of capture for that gas that migrates beyond adjoining property. And what that means is if gas migrates beyond property adjoining the storage field, it, for all purposes, becomes the same as native gas. And it's subject to the ownership and replace doctrine and to the rule of capture. And that's really where the 10th Circuit, at Northern's urging, went wrong, because they separated out the rule of capture from the oil in place doctrine, ownership in place doctrine. And the ownership in place doctrine and the rule of capture are really two sides of the same coin. They go hand in hand. And the 10th Circuit went wrong when it held, no, the rule of capture doesn't convey any ownership interest. It gives you the right, if you hurry up and produce the oil and gas, you then own it. But that's simply not what Kansas law says, particularly in both Martin Pringle and in One Oak.
I take it then that you would take issue with your opposing counsel's interpretation of 55-1205.
Yes, I would.
And so help me understand that, because as I read the statute, it does appear to say that in the condemnation action, the property owner is only entitled to receive compensation for native gas.
55-1205, which says exactly that, was passed way back in 1951. And if you try to reconcile that whole section of the statute, including the passage of 55-1210 in 1993, what you get is 55-1205 is intended to operate when the storage field is first being condemned and established. And so when you're taking the property rights there hasn't been any gas injected into that storage field yet, and there's only native gas to value.
Well, what are we to do with that statute in this circumstance? Are you suggesting that it just simply does not apply?
I think it does not apply, because 1210, in fact, I'd like to point out, and this is not in the briefing, The title to 55-1210, again passed in 1993, is, quote, property rights to injected natural gas established. That has to mean the statute occupies the field insofar as injected natural gas is concerned. And as I said a minute ago, if gas migrates out of a storage field beyond the property next door, adjoining property in the definition of the statute, it becomes for all intents and purposes the same as native gas, and therefore is subject to the ownership in place doctrine and the rule of capture. And particularly, I think we need to focus on what Martin Pringle said about Union Gas. Again, Northern's really only argument is based on Union Gas. Martin Pringle said Union Gas was superseded by statute, as explained, or I'm sorry, 1-0 specifically said that Union Gas was superseded by statute as explained in Martin Pringle. And so what Martin Pringle did was take the passage of 55-1210 and say, what does that do to Kansas law? And the Martin Pringle case said expressly that, and Justice Biles asked Mr. Olmsted about it, it says that the landowners north of the field had the right to ownership and produce the gas under their property until Northern got a certificate of expansion authority and paid for the privilege through a condemnation action.
What it actually says is the right to produce. It doesn't talk about title. And you guys on your side spend a lot of time equating the rule of capture to title. And I'm not sure that follows as I read this. It's not saying you have the right to go grab this gas that's underneath your property. It doesn't mean it's yours. I don't know that title actually gets talked about in this, and that gets you back to the migrating nature of all this. But in the end, what Martin Pringle talks about is your ability to produce. It doesn't say anything about your ownership of it.
Well, I think when you read Martin Pringle along with 101, it does, because both of those cases say that under the Kansas common law, oil and gas in the ground under your property, you have a present estate in that. And insofar as injected gas is concerned, well, actually this applies to native gas as well. If native gas migrates away from your property and onto somebody else's property, they then have the present estate in that oil and gas. And present estate has to include ownership and production. It simply has to. And the other thing that Martin Pringle said about Northern's theory is the Martin Pringle court rejected this instant revesting theory. Again, it's analogous. It's not exactly the same argument. There, Northern was arguing that the passage of 55-1210 affected an instant revesting of ownership in the gas. Here, they're saying it was the FERC certificate. It's another, action. But what Martin Pringle clearly rejected was this instant revesting theory, and they said, quote, Northern divined that a key principle emerged from Union Gas's holding on the certificate date offset, which Northern stated as, quote, title to migrated storage gas previously subject to the rule of capture revests in the injector immediately when the rule of capture ceases to apply. Of course, Union Gas said no such thing. That's a direct quote from Martin Pringle. And that's such a clear statement of Kansas law, along with the get a certificate and pay for it through a condemnation action. But Northern's argument that somehow the issuance of a FERC certificate, in which the landowners and the producers didn't have an opportunity to do anything, somehow changes the title to the gas, is wrong. And to your question in terms of the condemnation action, what Northern's argument that was accepted by the 10th Circuit really means is the landowners and the producers, through their leases from the landowners, had a valuable property right on June 1, the day before the FERC certificate issued. And in the condemnation action, as it went through Judge Balot and the three-person commission, that valuable property right to produce the gas that was there on the date the FERC certificate issued amounted to, I don't remember the exact number, but it's somewhere in the $6 or $7 or $8 million range. And the 10th Circuit reversed that and said you didn't have title to the gas because that was taken away by the simple issuance of the FERC certificate. We don't think that can be the law in Kansas. You just can't square that with the statements of this court in Martin Pringle and in One Oak One.
Well, that was obviously the intent of the federal regulators, wasn't it? When they issued the certificate and said you can't inject any more, the intent was to allow Northern to recoup its injected gas. I mean, that's the only reason to have issued that, isn't it?
No, I don't think so. I think what FERC is allowing Northern to do by granting them that expansion is contain your gas. The FERC certificate says absolutely nothing about property rights or that you get to go get your injected gas back. In fact, it says just to the contrary. It says this authorizes Northern to go acquire by condemnation or private agreement the land within the extension area. And that's precisely what we're arguing Kansas law requires them to do. The mere certificate, as Justice Biles said, they could walk in and abandon that. And is the ownership interest going to bounce back and forth during that period of time? That doesn't make a lot of sense. But what does make sense is if the gas has migrated beyond adjoining property, which is clearly what 1210C says, as interpreted in One Oak One, that means the rule of capture applies to it. If that gas is under the extension area on the date FERC issues its certificate, it's a valuable right, and Northern can't take it without paying for it. And that's clearly what Martin Pringle said. And the other thing I would say is, if in One Oak One, this court thought that the FERC certificate changed everything, why did it remand the case? The FERC certificate and the date of its issuance was all over the record in One Oak One.
Yeah, but we wouldn't have the ability, the district court changed its order. So the order that comes up to us, we don't have jurisdiction to be playing around with what happened afterwards.
Well,
I mean, we only have what the district court
I agree
order
with that,
says.
but what Northern has tried to do in its briefing in this case and its briefing to the district court, or to the 10th Circuit, I mean, what they've tried to do is take this court's limitation of its ruling in One Oak One, in which you said up to the date of the FERC certificate, and turn that into a ruling that you thought the FERC certificate changed everything. Read their brief again. That's exactly what they argued, and that's what the 10th Circuit bought. And 5 of you, I think, sat on that One Oak panel. I don't believe you thought that you were deciding that the FERC certificate changed everything. If you thought so, it could have been said a lot clearer. And we think you did exactly what you just said, Justice Biles. You limited your opinion because the district court had limited its opinion.
And just to get clear, though, to rule in your favor, we have to say first that Union Gas is no longer good law, or is no longer good law, and we have to say the 10th Circuit was wrong, even though your certiorari petition was denied, and so the U.S. Supreme Court didn't take the case. I realize you don't want to read too much into that, but we have to repudiate both Union Gas and the 10th Circuit opinion to hold your way.
You certainly have to do exactly what One Oak did or said about Union Gas, that it's been superseded by statute. That, to me, to us, that has to mean it's no longer good law. Northern effectively argues that, well, it was superseded only in part by 55-1210C. That's not what this court said in One Oak. It said it was superseded by statute as explained in Martin Pringle. And that says that. The Tenth Circuit, we think, simply misreads Kansas law, particularly misreads your opinion in 101. Because the Tenth Circuit bought Northern's argument that when you said they had the right to produce up until June 2, 2010, when the FERC issued its certificate, the Tenth Circuit essentially said that means you thought the FERC certificate changed everything. I don't believe that's what you did. I think you did exactly what you said, Justice Biles. You followed the district court's guidance, and because he limited his ruling, because FERC had issued the certificate after he had entered summary judgment for the producers, he limited his ruling and said, I'm not ruling beyond that. We'll address that whenever it comes up. And you did the same thing in 101. And you can't turn that into a finding that the FERC certificate changed everything. And we do think Union Gas has been superseded. We think the Tenth Circuit was wrong, and this court needs to announce what Kansas law is in this regard.
You mean 10th Circuit was wrong as a matter of state law?
As a matter of state
They
law.
weren't purporting to decide this on any other grounds other than what is the state of
Oh,
Kansas
that's
law.
absolutely correct. They acknowledged this issue is controlled by Kansas law, and they went through and analyzed Anderson.
So
and
given
Union
that
Gas.
the 10th Circuit's opinion may be persuasive, but this court has the final say as to the
Absolutely.
status of Kansas law.
I wouldn't admit that it's persuasive, but it absolutely is not controlling on this court.
Mr. Armstrong, just to give me a little context, what is, in light of all this litigation, what is the current status of the gas being produced in these fields and the storage capacity and all that?
Well,
What is happening?
the wells that existed in the extension area that the FERC certificate in 2010 applies to, those wells were shut down either very shortly after the issuance of the FERC certificate, or in one instance, I think in February of 2011, the next year.
So they've been shut down since the issuance of the certificate?
Yes, all wells in that area have been shut down since February of 2011. And the gas that was produced from those wells from the date of the FERC certificate until the shutdown is currently being held in suspense pursuant to an order of the Pratt County District Court in
Since
this case.
2011?
Yes,
About 8 months worth of production.
that's right. I think that's right.
And that's all we're fighting about here today, isn't it?
No, it really isn't. This court's ruling on this issue.
Well, I know you want the issue, but what is in controversy is production from June 2nd, 2010 until shutdown sometime before the eminent domain order, the condemnation.
That's correct insofar as this case is
Well,
this case.
that's my question.
Yeah.
That's what's in controversy in this case.
In this state court case, the money held in suspense pursuant to the Pratt County order for the production that took place after the certificate and up to the date of shutting of the wells, that's what's at issue in the Pratt County case. But the court's announcement or pronouncement or ruling on what Kansas law is in this situation directly impacts the condemnation case that's pending in federal court on remand from the 10th Circuit and what we call the 1405 case, where Northern is actually, clearly in your 101 ruling, said up until June 2, 2010, the producers had the right to produce. And when this case went back down to the Pratt County Court after 101, that money that had been held in suspense was released to the producers and landowners. Northern, in its 1405 case in federal court, is trying to get that same money back under an unjust enrichment theory. So this court's pronouncement in this particular case is going to have a direct impact on both of the other cases pending in federal court. And we're trying our best to litigate those cases, but this court needs to tell the federal courts what Kansas law is in this regard.
Do we have any further questions? All right, thank you, counsel.
Thank you.
In response to the questions that were asked at the end, what is that issue in this case, Justice Johnson, is about 8 months of production and the value of which is about $3.5 million. But obviously, whatever decision this court has will have bigger implications in other litigation involving the parties. And why that is so important to the producers is because in the condemnation case, they asked that Northern not only pay for the $5.5 million worth of storage gas that was underneath their property on the date of taking, they've also asked that Northern be required to pay $200 million for 25 years of storage gas production that they would have produced had their wells not been shut in and had there been no condemnation. That's why we're here fighting today.
And is there a native gas claim as well?
Excuse me?
Is there a native gas?
Yes, findings have already
compensation?
been made. There will be small amounts paid for native gas. There was a trial, a 4-week trial on this where lots of evidence was presented, and the findings have been made that there has never, in the history of time, there was never any native gas accumulation in the area where their wells are. It was full of dry holes. There was exploration, never gas produced. The native gas that is out there is native gas that was remaining in the Cunningham field, and when Northern began injecting its storage gas into the field, it pushed storage gas along with that remaining native gas out into this area.
Do I recall the facts correctly that from the federal court that it was like an 85% number for storage gas versus the native? I remember there being an apportionment.
That was in Union Gas. There was a 17% native. In our case, I all but 6 or 7 of the wells were producing 100% storage gas. On the very periphery of where the container seals off, there's some native gas that gets pushed to the periphery, which is actually consistent with the court's holding in Union Gas that recognized when you inject gas into a field for storage, it pushes gas and any native gas remaining gets pushed to the periphery. And ultimately, that's exactly what we experienced in our case. So what little amounts of native gas was there is all in the periphery, and there's only a handful of wells that have native gas in them.
I understand that's the circumstance we have before us, and we obviously limit our consideration to those facts, but then we have to deal with the reality that there could be situations where this rule will affect what might be fairly large quantities of native gas.
Well,
And so the certificate can shut down that native gas production that might be more substantial than it is here.
It is, and the Kansas legislature has recognized that situation since 1951 with KSA 55-1205. It says in this situation, if you get a certificate and there are large accumulations of native gas, the landowners get paid for all of that native gas. There's no
But
reduction.
not until, under your interpretation, there would be a gap from the certificate until the condemnation. There would be no, they would eventually get payment, but they have lost their production of that native gas for whatever period of time those legal actions take. Is that
Right, but they're not losing the gas. They're getting the value of the gas, and then when you ultimately figure net present value and interest and things of that nature, they're fully compensated. That's the purpose of condemnation, is to fully compensate somebody, just compensation for the property values being taken.
Would you address your opposing counsel's suggestion that 1205 only applies to the initial taking, not to an expansion of the storage field?
Well, notably, that argument is made without any reference to authority, without any reference to the judicial history of the Kansas Storage Act. It would be guessing on the part of the court to assume that that statute was only intended to address initial certifications. And in fact, case law is replete, not necessarily in Kansas, but throughout the country where there's gas storage, case law is replete with situations where underground gas storage fields need to be expanded from time to time. Because ultimately, what you're dealing with is gas being injected 4,000 feet beneath the ground. And there's no way to pull back the layers and look and see exactly what's happening. So what happens is over time, you get more data and more information, which has been our experience. And that data and information lets you know what's happening under the ground, and sometimes you have to react to that data. So the law, both federal law and Kansas state law, through the KCC certification procedure, recognize that situations arise where storage operators need to expand it. And despite that recognition that there are expansion situations needed, the legislature has never changed 55-1205. There's no substitute for 55-1205 that addresses expansion situations. The statute doesn't draw a distinction. It only addresses condemnation of areas that are going to be used for underground gas storage. I think ultimately, balancing is the important thing to note here, because what we're discussing is...
And you're balancing because you would agree that under Kansas law, the producers and landowners have incidents of ownership in the injected gas, in that they are able to capture it, take it, use it, consume it freely.
Yes.
And why isn't that an incident of ownership?
Well, I don't know that I would refer to it as an incident of ownership, but any oil and gas lease in
But
the
it's
state of
it's
Kansas.
an interest in that gas. They have a valid interest in that gas if they can capture it, sell it, and spend the money, right?
They have the right to produce that gas, to capture it, for lack of better words.
And
They
why
have a
isn't
right.
that an interest in that gas?
I don't know that it isn't an interest. It is a right to produce it, to capture it, but it's not an ownership interest in any way.
Well, whatever you call it, it's an interest in the gas. And my question then is, why does FERC get to determine the disposition of a Kansas property interest?
FERC
Why
doesn't-
isn't that the purview of the court in the Condemnation Act? The Kansas court says what happens to Kansas property instead of a federal agency.
Well, and that's exactly what happened. FERC doesn't decide anything with regard to ownership of gas. The ownership
Well,
issue.
you just argued that.
No,
Once
no.
the FERC certificate is issued, then the rule of capture, which you've already admitted has some incidence of ownership or is an interest in the gas, is destroyed. And so FERC is actually destroying an interest in property for Kansas property.
I respectfully disagree, and I think I must not have made my argument clear. FERC expands the certificated boundaries of the storage field. Upon that expansion, FERC says nothing about rights, interests, or anything. We go back to Kansas law. Kansas law says because the government has certificated that field for storage, on the date of that certificate, Kansas law is going to recognize Northern Storage Operations as being officially sanctioned. Its storage gas within its newly certificated area becomes an exception to the rule of capture in Anderson. So the right that the producers had to capture storage gas, whatever interest they had in that gas before the date of certificate, it expires and has always expired by operation of Kansas law. It has nothing to do with federal law. By operation of Kansas law, that right has always expired whenever the area of their wells is certificated. It has never existed. So they did not lose anything. The right to produce storage gas from within the certificated boundaries of a storage field has never existed in Kansas. Professor Pierce, and I hate to go back to him, but I believe hits the nail on the head. He recognizes that this is a balancing situation. And ultimately, the state of Kansas law today is this. In Anderson, that addresses a situation where we have an injector of storage gas that's neither a public utility and has no certificate. That's not us. Union Gas balances a producer's right, pursuant to their lease rights, to produce the gas beneath their property when it is storage gas, with the injector's rights to protect the storage gas that it has stored under contract, and holds that the right to capture ends when certification begins. Martin Pringle merely recognizes that right, which is a valuable right, the right to capture storage gas. That right, if there is no certification, cannot be taken away retroactively by the legislature because it's a substantive right to produce. And Martin Pringle, Mr. Armstrong pointed out the Martin Pringle language that said Union Gas says no such thing. The very next sentence in that holding says Union Gas says no such thing because Northern has not utilized the remedy of getting certification, and as a result, its gas is subject to the law of capture in Anderson. So of course, Northern did, after Martin Pringle, it went and got certification. So finally, we have Anderson, Union Gas, Martin Pringle. One Oak pulls all those things together and harmonizes them. And what One Oak says is 55-1210 did alter Union Gas in one material respect. After 55-1210, an injector no longer needs to certificate adjoining property to protect its gas. It can protect its gas by statute without certification. But when the gas gets beyond adjoining property, the common law rule of capture of Anderson and Union Gas applies. The court didn't say that gas has been transformed to being native gas. It said the common law rule of capture, when we get beyond adjoining property, applies. So they have the right to capture that. Today, there's no reason why dealing with the exact same wells in the exact same area, the common law of Anderson and Union Gas does not apply. Union Gas says in this situation, once the certificate is issued, that gas is no longer subject to capture. Northern believes the district court got it wrong, and we ask the court to reverse this case and remand it for further proceedings.
Do you have any more questions? All right, thank you,
Thank you.
counsel. We thank both counsel for your arguments this morning. Court will take this matter under advisement.